Here is the core issue that most citizens are entirely missing. The Supreme Court is not merely engaged in a narrow review of Hawaii's flawed statute. They are actively weighing a far more monumental question that cuts directly through the legal foundation of every single permit system in the country. The question is fundamental. Does the constitutional right to carry initiate with you, the citizen, or does it criminally start with the government? Because if the definitive answer is you, then every single state that engineered its firearms policies around the illegal tenet of permission first, right second, instantly loses its entire legal foundation. And the blue states are acutely aware of this existential threat. That is why they have aggressively deployed every resource to defend these crumbling systems. Once the court establishes a clear, unassailable line, it will be irrelevant whether the state is Hawaii, California, New York, or Illinois. The entire model collapses, and here is the precise threat that induces sleepless nights for those restrictive states. The court is not evaluating sentimental emotion, dubious statistics, or political forecasts. It is strictly analyzing history, the identical constitutional test that Bruen formally demanded. And when you meticulously examine that history, there is zero legitimate support for forcibly compelling free citizens to beg for permission before exercising a recognized, enshrined right. That is why this case feels exponentially larger than the mere paperwork currently before the court. It is not just about specific carry laws. It is about irrevocably deciding who holds the default power, the individual citizen or the regulatory state. And the moment the Supreme Court delivers that answer, everything else in the permit landscape falls into total disarray. This is the critical inflection point where the stakes expand massively beyond the limited geography of Hawaii. Because if the Supreme Court formally strikes down Hawaii's model, the devastating impact will not halt at the edge of the Pacific Ocean. It will roll across the entire country in an unyielding straight line, structurally dismantling every single state that aggressively copied the exact same evasion strategy post-Bruen. Hawaii did not invent this permission-first system. It simply created the boldest and most legally indefensible version of it. And that singular fact makes it the perfect legal test case. States like California, New York, New Jersey, Maryland, and Illinois constructed nearly identical legal structures, aggressively hoping that if they all moved in lockstep, the federal courts would be hesitant to strike them down individually. If Hawaii loses, the protective shield they desperately built for one another instantly vanishes. What renders this situation even more politically and legally tense is the timing. Dozens of firearms lawsuits are already idled, languishing in lower courts, anxiously waiting for this one. Definitive signal. Lawyers have temporarily halted new filings, judges have delayed critical hearings, and the restricted states have been ruthlessly buying time, desperately hoping the Supreme Court will ultimately decline to intervene. The exact moment a ruling lands, every single one of those paused cases simultaneously activates, and the states that aggressively attempted to bury carry rights under mountains of administrative restrictions suddenly find themselves forced to defend laws they already know are legally and constitutionally tenuous. This is not a slow, glacial shift. It is the specific kind of systemic change where once the first domino tips, the remaining pieces do not get a say in the matter. And right now, every restrictive state intently watching Hawaii knows exactly where they stand in that collapse sequence. The instant the ruling was released, the first citizens to feel the shockwave were not career politicians or tenured judges. It was law enforcement. Overnight, police departments found themselves straddling two incompatible worlds: the rigid old permit system they had been legally enforcing for decades, and a terrifying new legal reality where those permits might suddenly be legally void. Some county sheriffs immediately and publicly declared the permit check requirement dead on arrival. Others, paralyzed by habit, continued to enforce them, deeply terrified of making the wrong call and ending up subject to massive litigation themselves. Prosecutors in multiple states quietly initiated the process of dropping existing permit violation cases, not because they agreed with the ruling, but because they absolutely refused to be sued for enforcing a statute that might already be declared unconstitutional. And while police officers aggressively scrambled to determine what regulations they were even permitted to enforce, gun control activist groups erupted in chaos. Press conferences, desperate fundraising blasts, emergency strategy calls, the entire political apparatus immediately entered panic mode. They fully understand this is not merely a policy loss, it is an existential, crushing blow. Their entire restrictive playbook depends on permits, intentional delays, and endless administrative hoops. And suddenly, that entire foundational structure is riddled with irreversible cracks. Police are trapped in legal limbo. Activists are frantically scrambling for a political lifeline. The ruling did not just shake the system, it exposed how fundamentally fragile it truly was. One crucial facet of this systemic shift that most people are not publicly discussing, but which every state accountant certainly noticed, is the financial catastrophe. Permit systems were never merely regulatory tools. They were highly effective revenue engines. Application fees, mandatory renewals, compulsory training classes, certification programs, background check surcharges, it all cumulatively totaled millions of dollars each year. And overnight, that consistent flow of revenue began instantly evaporating. States that structurally relied on this permit revenue to fund administrative offices are now desperately trying to ascertain what those offices are even legally supposed to do without the steady, endless stream of applicants. Some are refusing to wait for an official answer. They have already begun the process of canceling scheduled training sessions and rapidly refunding unused fees. And it is not only government budgets feeling the shock of insolvency. Private instructors, certification corporations, and state-approved training contractors are watching their entire business models collapse. Many aggressively built their operations around mandatory courses that are now instantly legally questionable or have become completely optional. The old permit system intentionally created a localized economy of compliance. This ruling exposed how fragile and non-essential that economy truly was. What replaces it remains unclear, but one truth is undeniable. The oppressive era of charging citizens for permission slips is concluding with extreme velocity. Now, if you zoom out for a wider perspective, this ruling is not an isolated legal moment. It is the definitive next link in a chain the Supreme Court has been meticulously forging for almost 2 decades. It commenced with Heller in 2008, when the court finally and publicly acknowledged what gun owners already knew. The Second Amendment protects an individual right, not a convenient government-granted privilege. Then arrived McDonald, which legally applied that right to every single state, shutting down the cynical idea that local governments could manufacture their own unconstitutional versions. Accelerate to Bruen, and the court formally added the mandatory historical rulebook. If a modern gun control statute does not align with America's specific historical tradition, it is constitutionally void. This new decision is the logical, inescapable next step, and it provides the final answer to a question the others failed to fully settle. Do constitutional rights begin with the government's approval, or is the government legally forced to justify every single limit it attempts to impose? The court has finally and definitively closed that gap. Permits were legally abused as an unconstitutional gateway for too long, and this ruling snaps that entire structure off its hinges. If Heller formally recognized the right, McDonald aggressively spread it, and Bruen clarified the legal test. This monumental decision definitively enforces it. Once the initial legal dust settles, the prevailing national question remains. What does a permitless America actually look like? The uncomfortable truth is that the necessary shift will not occur in one dramatic, decisive moment. It will be systematically unfolded, state by state, policy by policy, as desperate lawmakers frantically scramble to adjust. Some states will rapidly update their statutes because the ruling leaves them no available room to stall. Others will attempt to drag their feet, hoping to invent new, punitive requirements that feel like permits without actually using the prohibited word. But the legal landscape has fundamentally changed, and federal courts are not granting much latitude for creative, restrictive detours. We are entering a new era where we will witness lawsuits accelerating exponentially, political pressure building fiercely on states with restrictive systems, and a nationwide legal push to align every local rule with the court's new, strict constitutional standard. Mandatory training requirements will shift toward voluntary education instead of government mandates. And the entire antiquated notion of proving your eligibility before exercising a constitutional right is irreversibly fading out. It will not follow a perfectly straight line, but the direction of travel is clear. The country is moving toward a world where the right to carry does not begin at a county clerk's counter, a mandated classroom, or a filing window. It begins and ends with the citizen. Amidst all the excitement and systemic panic surrounding this landmark ruling, a massive number of people are asking the same crucial question: are firearm permits really disappearing in 2026? The sober, unvarnished answer is this: the ruling has shattered the core legal foundation that permits have relied on for decades. But the practical, on-the-ground rollout of change will not affect every state at the same speed. Some states are already treating their permits as legally optional. Others are aggressively rewriting their core statutes to stay ahead of the massive incoming lawsuits. And a small defiant few are digging in their heels, foolishly hoping the legal storm will simply pass them by. It will not. The single most critical difference heading into 2026 is that the burden of constitutional proof has completely flipped. States can no longer attempt to defend their restrictive permit systems by simply asserting, "This is how we've always done it." Now they must legally and historically justify every single rule under a stringent historical test that grows sharper and more demanding with every single case that reaches the courts. That means long bureaucratic lines, cripplingly high fees, and subjective, arbitrary approvals are now all rendered legally unstable and endangered. Are permits ending overnight? No. Are they now placed on a ticking clock? Absolutely. And that clock is running louder and faster every month. So that is the legal reality where we currently stand. A Supreme Court fully prepared to aggressively redraw the rules. States scrambling desperately to politically keep pace. And a permit system that has run out of all legitimate legal excuses. The next political moves will not be subtle, and they will not be slow. They will definitively decide what you are legally able to carry, where you are legally able to carry it, and whether those unconstitutional permission slips become historical relics of the past or rise back from the dead in a subtle new disguise. If you demand the truth before the headlines deliberately twist it, if you demand updates without the political noise, and if you want to understand these rulings before they criminally impact your doorstep, you must stay with this channel. And trust me, what comes next in this legal war is bigger than anything